Good. Welcome. I'm Kevin Banks, the director of the Queen's Center for Law in the Contemporary Workplace. The Center is delighted to present to you today a talk by Professor Alan Hyde. Professor Hyde is internationally recognized as a leading theorist and analyst of a wide range of labor and employment law issues, ranging from the very conceptual foundations to the discipline to topics such as the enforceability of noncompetes, which we're going to consider today. He earned his bachelor's degree from Stanford University and his JD from Yale before joining the faculty at Rutgers, where he is now the Sidney Reitman Scholar and a full professor of law. He did visitorships at New York University Law School, Cornell, Yale, Columbia, Cardozo, and the University of Michigan, among other places, and Toronto. So we're delighted to have him here at Queen's today, and I'm going to turn it over to Alan. Thanks.
Thanks, Kid. Thank you so much for having me. Is the mic on? Can you get me? Very, very happy to be at Queen's University. I was in Kingston only once that I can recall, passing through on my way to Critical Legal Studies summer camp, which used to take place in rural Ontario. I'm afraid I've long since forgotten the location. I thought it was a very pretty spot and someplace I wanted to come back to. My son sailed here some years ago in the summer regattas, but I myself didn't have that pleasure. So my topic today is the contracts that are sometimes known as covenants not to compete, sometimes restrictive covenants. Both these terms are cumbersome in the States. Everyone calls them non-competes now, and I gather that usage is at least known in Canada. But if it sounds vulgar, I'm sorry, but that's what we do it. And I want to come out swinging and say that as nearly as I can figure out on the basis of some recent economic studies, there's no social advantage in enforcing non-competes, and that we would all be better off with some legal changes, at least minimizing their enforcement, putting the burden of proof on stronger burden of proof on plaintiffs and the like. Let me apologize right from the outset for the Americocentric nature of these remarks. As Kevin will tell you, I'm a pretty global kind of guy. Kevin and I got to know each other because we both work on issues of global labor rights. And oh, there's an interesting slide. What happened? There are subheads that aren't showing up, right, which doesn't matter here, but will matter soon enough. Yeah, let's do that. Okay, I'll just work from here. Right. Anyway, usually when I lecture in my own country, I try to take a global perspective on things, and certainly when I'm a guest in somebody else's. I first began working on this problem not thinking about the states as such, but in an incredibly narrow geographic scope, thinking about Santa Clara County, California, otherwise known as Silicon Valley, and the tech district around that. And that's the context in which I first began thinking about these problems. This happens to be an area of law where the variation among the American states is extraordinary. So it's tough to stay just on top of legal developments in my own country. But as we used to say in the 60s, today is the first day of the rest of my life. I am committed to a book chapter with an Italian law professor, which will be a comparative law treatment of these themes. I agreed to this unencumbered by any actual knowledge of any country but my own. So today, I am truly, people say this, but I'm letting you know, folks, I really am here to listen as well as to talk. I hope to come home today with some sense of how these issues play out, at least in Ontario, possibly in Canada, and to move into a comparative dimension in the future. So you are warned. So these remarks today are adapted from a forthcoming book chapter, which is pretty tedious. But if you actually want to check down any, and it is not yet out, but my chapter is available on SSRN if you want to check any of the references, or just ask me afterwards. Okay. So we deal with non-competes, and I find that most people find non-competes very difficult to think about and impossible to think about if you want to have a strong starting point, because whichever starting point you start from, you can reach any result that you want. Just before the presentation, I was learning of a presentation here on copyright from a feminist point of view not long ago in this law school, where the lecturer was taking the position that there really shouldn't be any copyright because all knowledge belonged to the people. On the other hand, some people come into this field by thinking about their artist clients and their creator clients, and they tend to want strong intellectual property claims for everybody, on the analogy to artists. Another vexed starting point would be whether you see this as a subset of freedom of contract or freedom of competition law. Students are, at least in my country, are often exposed to non-competes in their basic class on contracts. Is that true here? So in that context, the law of non-competes appears like an anomalous exception to freedom of employment contract. I mean, normally we say the strength of North American systems of employment law, certainly as compared with Western European systems, is relative freedom of employment contract. Employers, employees free to reach all kinds of employment contracts. We don't have these rigid, standard employment contracts as they have in Western Europe. And in that context, why should competition clauses, alone among clauses, receive such searching judicial scrutiny for reasonableness? Why aren't employers and employees free to reach any result on these issues? So there's a way of making the field look anomalous from a freedom of contract point of view. But one can equally well start from competition law and make it look equally anomalous in the other direction. Right? As a general matter, producers are not permitted, in the law of your country or mine, to enter into an agreement saying that only one of them will do business in a town. A famous teaching case in America was a Supreme Court of Wisconsin case in which the Fullerton Lumber Company of Clintonville, Wisconsin, was permitted to enforce a non-compete against its departing sales manager, a man named Al Torborg. Well, why should that be permitted? If Fullerton Lumber, Home Depot, and Lowe's entered into an agreement that only one of them would sell building supplies in Clintonville, Wisconsin, that agreement would be unenforceable per se. You would not look to the impact on consumers. You know what the impact on consumers is going to be if producers can limit competition that way. So from this perspective, the fact that any non-competes are enforced is also anomalous. It's an exception to our otherwise strong rule against anti-competitive agreements. So I find this would make strange bedfellows. Depending on, you can start this analysis from a number of different starting points. You can then reach whatever result you want, but it's very hard for me to solve this one as a matter of legal theory, which is why there's so much data in this one. Okay, let's start with a legal standard, and you can tell me in the Q&A if this sounds familiar or different. The most carefully worked out legal standard in the United States has just been worked out by the American Law Institute in its current project of restating American employment law. It's a bit cumbersome and has a lot of moving parts. But as you'll see, at bottom is really quite vague and hard to interpret. We have covenants. Today, by the way, I'm restricting myself only to covenants not to compete. I believe that the economic argument works just as well with trade secrets, invention agreements, non-disclosure agreements, invention assignment agreements, but I just don't have the empirical literature on those, whereas I do have some empirical literature on non-competes. From my perspective, economically, they're all exactly the same thing. I'm also limiting myself to the departing employee context. Non-competes in sale of business are always seen as presenting a different problem, and I don't want to go into that myself, although you certainly could in the Q&A. And so I'm limited to non-competes against departing employees, and the usual justification for enforcing them when they're enforced, which is not always, is some kind of intellectual property interest. We have to prevent this former employee from going to a rival or starting his or her own firm because he or she will make use of our intellectual property, and that's the interest that supports the non-compete. All right. So in the U.S. context, which purports to state the American rules, but it does so at some loss of variation, a non-compete against a departing employee is enforceable reasonably tailored in scope, geography, and time to protect a protectable interest of the employer. And then there are these four exception clauses. We'll look in a second at what's a protectable interest of the employer. All right. So the first standard is the non-compete is enforceable if it's reasonable. At this point, my contract students usually break out into laughter, and who could imagine a vaguer standard than that? This seems to want a lot of attention from me. All right. So the restaters identify 4 factors which would make the non-compete unenforceable, even if otherwise enforceable. Certain kinds of inequitable discharges. Well, I don't know what those are exactly. Nobody knows. Employer bad faith, another vague standard. A material breach by the employer of the underlying employment agreement. None of these terms has a very defined meaning in American common law, I have to tell you. Or a special one that was very controversial, the ALI, but there are a few cases that involving doctors where medical practices are not permitted to enforce non-competes against a departing doctor because there's a need in that area for doctors of that specialty. All right. And then the guts of this, though, is that the employer, in theory, in order to enforce the non-compete, has to have a protectable interest, and the legitimate or protectable interest in restatement terminology, all again equally vague, include confidential information, customer relationships, investment in employee reputation, purchase of a business owned by the employee, which I'll leave out for present purposes. All right. So this is all pretty vague, I must say. The employer has to have a protectable interest, involves investment in employee reputation, or usually confidential information. Defining confidential information is not a day at the beach. Even if the employer has the protectable interest, the employer's non-compete has to be reasonably tailored to that interest. And then finally, the employer can't fall into one of the 4 exceptions which prevent enforcement of the non-compete altogether. So this is an attempt to divide it all up. And if, in my opinion, it's probably a little bit more pro-defendant, pro-employee than the law actually applied in American jurisdictions. But it's very hard to generalize. There's a tremendous number of flashpoints among American jurisdictions. It's not really clear to me that all of them really require the employer to show a legitimate interest. There are certainly non-compete cases that say, the employer asked for it, the employee signed it, freedom of contract enjoined. And it's not really clear how much courts go in requiring the employer to show a legitimate interest. Others go quite far in requiring the employer to show some kind of legitimate interest, typically in intellectual property. If you're looking for a legitimate interest at all, the question is what makes it legitimate. Entertainers who have a certain appearance before the public, TV newscasters, for example. Those cases come out either way in my country. Is the TV newscaster's reputation with the public the employer's property or the employee's property, or something in between? When we get to defining reasonable time and scope, all bets are off. Florida says anything over 2 years is presumptively unreasonable. Pennsylvania routinely enforces covenants of 3 years or more. Does the industry matter? There's a much-cited New York case that said, in the Internet industry, 6 months is a lifetime. Another flashpoint issue, which is a little less controversial today than it used to be. Suppose the employer comes in with an overbroad non-compete, too many years, too big a geographic scope. Does the court say, you had your chance to draft a reasonable one, you didn't, get out of here? Or does the court rewrite it to make it reasonable? This was a controversial issue in the 50s and 60s. My impression now is, and the restaters claim, that almost all American courts will rewrite the covenant to make it reasonable, even if the employer neglected to do so. And then finally, at the other extreme, you have American jurisdictions that do not enforce non-competes, most prominently California. But a number of Western states, it's almost impossible to get a non-compete enforced. California really is impossible, as the California Supreme Court reaffirmed just a couple of years ago. So, with all this going on, we have a rather natural experiment in my country where we can compare states along these lines, and that's just what I'll do in a minute. But let's get up to this. So, there is very little academic literature on non-competes. Surprisingly little, really. And there's a wonderful book by Catherine Fisk of the UC California Irvine School of Law dealing with 19th and early 20th century developments showing gradual employer assertion of control over employee inventions, mostly on a theory of implied contract. One of the points she makes in the book is that the whole concept of intellectual property showed up too late in the law to be of much value to 19th century employers. So anything historic, I rely on her. But another reason for the lack of attention during all this period to the law of non-competes, I think, is that really until the 70s or 80s, most large American employers, certainly in manufacturing, in science and tech, operated what are known as internal labor markets. They just didn't hire from outside. Okay? Think of something like a large automobile company in Detroit. Right? In those days, engineers started work at Ford or GM, and you stayed there until you got the gold watch. There was not a lot of inter-firm mobility of scientific or technical personnel. We had various monopolies and oligopolies in our country. The telephones was a monopoly of the American Telephone and Telegraph Company, AT&T. AT&T hired their technical staff when he, the gendered pronoun is advised, when he finished his service in the Army Signal Corps, which was how American electrical engineers were trained in that era. He went to work at AT&T. He stayed for a very long time. Where else was he going to go? He could come here, I suppose, but there weren't any other. What other telephone company was he going to work for? Right? In such a labor market, it doesn't matter what the law is on non-competes. No one's going to leave. And so you didn't have a lot of analysis of non-competes in those sectors. By the way, this is something that worries me about this comparative law project heading up with my Italian colleague, because I do happen to know that in Italy today has absolutely the lowest job mobility of managerial and scientific personnel anywhere in Europe, even lower than Germany. And they just don't leave. So, while I'm sure that my Italian co-author is able and intelligent and all that, he's just going to be coming from a very different place than a North American would on this. Okay. And as I said before, in the 50s and 60s, the main issue in U.S. courts was whether to rewrite the non-compete. And the answer was yes. And there's almost no economic analysis of non-competes from before 1990. All right. Following 1990, an arbitrary date, 4 factors combined to put new scrutiny on non-competes. I will start with the economic theory. Obviously, socially, it's the least significant. People don't start re-examining things because there are good articles by economics professors. But I'll start with that to give you my framework. There was new interest, certainly in my country, in startups, so less fascination with the Chandlerian Corporation. There was particular interest in high-tech industrial districts like Silicon Valley, California, which is how I got into this field, and a decline of internal labor markets and implicit contracts for lifetime employment. These are pretty familiar, and I guess I'll go through them quickly. Again, if you've got problems, yell. The chief economic analysis of information, almost all economic articles written about information, I'm exaggerating, but not a whole lot, before the 90s were dominated by a very important paper by Kenneth Arrow in 1962. Most economists assumed that information could have value only if it was somebody's property. And that a problem, and this literature saw it as a problem, was that when information is produced, by the way, the kind of information I'm talking about in this talk, I should have said, is mostly information that's produced by private firms. Products, new products, inventions, patentable inventions. You'll see we're going to look at the patent database. Know-how, better ways of doing things. Okay, I'm not talking about people who claim information in the common property of mankind. I'm leaving out hot biotech issues like information in organisms and things like that. I'm just dealing with inventions and know-how and processes and protocols that firms discover, either how to do things better or to bring products to market. Now, that gets produced in an Arrow framework. But in an Arrow framework, every time you produce information, it spills over to rivals. That was his vivid metaphor. Before 1990, the literature saw this as a problem, not an asset. Right? If firms produce information and everything they produce spills over to their rivals, they're going to produce less of it. Information will have social value that won't be captured in individual economic value. There'll thus be underproduction of information. And for Arrow, the payoff was the government had to have an active role in creating information, supporting scientific research and the like. My economic analysis today, by contrast, takes place in a framework developed by Paul Romer of the Stanford Business School around 1990 in a really important article called Endogenous Technical Information. And in Romer's models, shared information, in his vocabulary, nonrivalrous and nonexcludable, is actually the key factor in economic growth. The precise reason why some countries grow faster than others, some regions grow faster than the others, is not really captured by human capital. It's captured by a more social kind of capital. There's more information around, and it's information that's shared across firm lines. Non-rivalrous, in Romer's terminology, which I'll try to use, is a technical attribute. Information that can be shared by many users at the same time, a formula, a protocol, is non-rivalrous. Basically, any information that's not lodged in a human body that can only be in one place at one time, that's rivalrous information. But almost everything else is non-rivalrous in Romer's terminology. And when Romer uses the term non-excludable, he's adding factors like legal status. Okay, so that if in Silicon Valley an employee wants to leave Intel and go to another firm, a rival like AMD, or start his own firm making chips, and Intel tries to enjoin the employee on a trade secret theory, and the injunction is denied. This would be typical in California. In Romer's terminology, the court has found that Intel's knowledge, the employee undoubtedly knows something that the employee learned at Intel, but the court has found that this information is non-rivalrous, it can be shared by many users, and legally it's non-excludable. Intel has no right to exclude other users from the information it created. The only reason I'm saying anything about terminology is that these sometimes now in more recent articles, people use, confusingly in my view, the word spillover to refer to this non-rivalrous information. Spillover used to be a bad thing, and now it's becoming a good thing. All right. We know from a series of articles and studies that among the most, first of all, studies seem to confirm Romer's insight that economic growth depends on a certain amount of non-rivalrous information. Again, this is the birth of the more modern revolutions in information and communication technology. And it's just clear to me because it happened in my lifetime. And well into the 80s, in the United States, we had a monopoly of both. AT&T was the phone company and monopolized communication technology. IBM dominated information technology. Right? And both those companies came under antitrust scrutiny in the 80s, 70s, and 80s, and the government succeeded in breaking them up to oversimplify. They broke into smaller components, and they became less proprietary about their information technology. And that's what created the modern revolution in information and communication technology. You could have all these engineers developing all sorts of things. You could have government scientists working on the Internet. But if you develop the Internet and the only entity capable of its commercial exploitation was the old AT&T, you wouldn't have communication technology as we have it now. You wouldn't have startup firms. You wouldn't have firms making apps and so forth in the old days when, as a de facto matter, most information about information and communication technology was the property of two American firms. If you accept that at least some kinds of growth require that some kind of information leak across firm lines and not be shared, there's no better way of doing that than having employees move around. This is not a new insight. A classic in the scientific literature is an article by Collins in '74 about a particular kind of laser called a T laser, where every single element of this laser was public domain. It had been written about in science journals, engineering journals. Still, nobody ever succeeded in building one except by employing an employee who'd seen one built before. And that's the only way you could ever build a T laser. But a really important article is Almeida and Koget's article from 1999 looking at when firms cite other firms' patents. And the main determinant seemed to be mobility of technical personnel. At the time they wrote, you had regions of the country where almost all the IT scientists worked for one company. In Texas, they worked for, this has changed in the last 20 years. But in Texas, they worked for Texas Instruments. In upstate New York, they worked for IBM. In Silicon Valley, they could work for a bunch of different companies. And this created very different patterns in patent citation. When a Texas Instruments engineer brought a product to market, he or she would cite only Texas Instruments patents. And the same is true for IBM personnel. But Silicon Valley was at that time the only region of the country where a lot of employees cited patents that had been taken up by other companies. And why was that? Well, as they looked closely, it had mostly to do with employee mobility. Patents are public information. Anybody can look them up, right? But the point was employees didn't if they worked for Texas Instruments, right? And since that time, the American economy has moved more toward the Silicon Valley model. And another amazing finding is that in more recent studies is that it's easy to do this research with patent citations. There's a wonderful database of patent citations, and there's a very heavy use in my article of patent citation literature. I'll try to find some other ways into the data, but I wish I weren't relying so heavily on patent citations. But it's real fun. You can buy this book by Trachtenberg. It comes with a CD in the back. You can plug the CD in. You can run searches for any patent citations you want. It's a lot of fun. I recommend it. All right. Not only do firms now cite patents from other companies, They are particularly likely to cite patents from regions or firms to which their former employees have migrated. Okay? In other words, today, when a tech company loses an employee and the employee goes to a rival, they're not actually losing an employee. They're opening up an information source. Right? There's so much consultation with people you used to work in what I've called a high-velocity labor market, where people change jobs all the time. When you're stuck on something, you phone somebody you used to work with and say, have you ever seen this? And if it's really proprietary information, they won't tell you. But if it's on the line, they'll check with their boss, and the boss will say, well, don't send them the most recent version. Send them the algorithm we were using last year, or talk them, and a lot of information flows up this way. And again, this shows up in the patent citation literature. People are much likely to cite patents from the firms where their former employees are working. All right. So it turns out that for all these reasons, employee mobility can be positive for productivity in tech firms. Now, I fought this tooth and nail in the 90s, as Kevin would probably, I don't know if you were ever at these meetings, right? I got into this in the 90s when there was tremendous concern in Western Europe and in North America with the decline of lifetime employment and the rise of rapid employee mobility. And most people treated this as an absolute disaster for labor law as we knew it. And it is indeed a disaster for many employees, don't get me wrong. But I kept saying at the time, it's a mixed picture. You know, some firms benefit from this mobility and some employees benefit from this mobility. And I took a lot of grief for that in the 1990s. People would jump up and say, well, you know, maybe it's true for a small group of employees. Or the other thing I heard all the time was that all this downsizing, outsourcing, use of labor market intermediaries, this is just a 90s management fad. And the firms will realize they've gone too far, and they'll go back to internal labor markets and implicit contracts for lifetime employment. Hasn't happened, folks, and I don't think it's going to. I think we're stuck with these problems. Anderson et al. Use census data. If the firm has high R&D expenditure, employee turnover will be positive for productivity. John About and his colleagues in an NBER working paper from 2007, they used census data. They didn't look at R&D expenditure. They looked at using advanced technologies. Same deal. Okay? The firms realized gains to employability, but not to experience. Now, that's an unusual finding in labor economics. Usually in labor economics, all things being equal, firms will realize gains to employee experience. You know, the senior employee is worth more to you than the kid out of school. It's true for many companies, don't get me wrong. If you've got an old line firm that doesn't spend much on R&D, doesn't use advanced technologies, they're not going to realize any productivity gains from turning over all the time. They will be losers that way. But there are firms, and increasingly that's the firms you want to protect in the economy, that will. Okay. In the 50s and 60s, where everybody was convinced that the large Alfred Chandler Corporation that realized economies of scope and scale was the efficient way of doing business. Now we understand there are startups. New to firms in particular are really only formed when managers can leave old firms. Of the three big automakers, two were founded back in the day by people leaving Ford. And in disk drives, in various kinds of pharmaceuticals and medical devices, the only firms that make money are the firms that are founded by managers and scientists and other technical people who leave old firms. And anything that impedes that process is going to show up in growth figures, as we will see. There's more of an understanding now that innovation in an economy doesn't just come from producers. Eric von Hippel of MIT has been beating this drum for many years. Most innovations these days come from users. Somebody makes a product, sends it out to the market, and then all the people using this product come up with the innovations. All right? A third source of information in non-competes, a source of interest in non-competes, was Annalise Saxenian's wonderful book on Silicon Valley, 1994, where she compared Silicon Valley in California to the high-tech district around Boston, known as Route 128, and how the Valley had beaten Route 128. And she identified the key factor for her was also information flows across firm lines, and what were the mechanisms of that information flow. People forget that in her book, there were three things she identified, and employee mobility was not the main one. She's an urban planner. She focused on social ties among scientists and engineers. Everybody said that was obsolete when she wrote the book, and it's definitely obsolete now. That's like a tribute to an older Silicon Valley that really had passed into history before her book came out. She mentions formal tech alliances, formal strategic partnerships, strategic alliance, co-production agreements, very important. I can't say anything about them today. And then she also mentioned employee mobility. And then, as I mentioned, the Almeida and Koga, which came along a few years later, looking at patent citations, concluded that employee mobility was really the key, at least for the problem they were looking at. I wrote my book, Working in Silicon Valley, in 2003, which was an inquiry as to what personnel practices look like in a high-velocity labor market where people change jobs all the time. And one weakness of that book, I cheerfully concede, was I didn't actually have any data that people change jobs more frequently in California. That was a stylized fact about the book. It's what tech managers who had managed in Boston or Toronto and then had managed in California thought was true. I didn't doubt that it was true, but I didn't actually have that data. Very few people have noticed that in the book, but I confess it to this distinguished group. Anyway, since my book came out, we actually have data on job changing in California, and it's true. Californians change jobs all the time, and people in the computer industry change jobs even more than typical Californians. All right. I'll skip Germany and New Jersey. I'll come back to them or talk about them in the Q&A. Okay. So, and then finally, as we've seen, the formal rules on non-competes don't matter if there's no mid-career market for engineers. But today, all large U.S. employers, not just in tech, but in auto and everything else, will hire top personnel from outside the company, and this puts pressure on the legal definition. It creates a possible alternative legal definition that my students really like, but so far as I know, there's no American case law support for. Many people think that the enforceability of the non-compete should depend on the underlying implied employment contract. In other words, if you really have an old line firm that offers lifetime careers to employees, it might be reasonable in the legal sense for them to insist on a certain monopoly of information because they're paying for it in a sense. Whereas if you've got some tech startup in California that's paying everybody in stock options and doesn't explicitly or implicitly promise anybody any job security, it would seem less fair, really unfair for them to insist on strong confidentiality of information. This makes a lot of sense to a lot of people, but I do not know of any American cases decided on that theory, looking to the underlying employment contract. All right. So, the hypothesis which I developed in my 2003 book with not as much data as I wanted was that there is a certain kind of technological economic growth that requires that employees, typically managers, scientific personnel, be permitted to depart for rivals and startups and carrying information with them. That's crucial. These will open up channels of information flow across firm lines. It'll actually benefit the old employer by opening up channels of flows. And there's a certain kind of tech growth that can only happen this way. And therefore, you would expect that jurisdictions that don't enforce non-competes should demonstrate this growth. And that's where things stood when I wrote my book in 2003. That's what I hypothesized, but I didn't have the data. There's a lot more data now, and it's very interesting. First, you can make, as a general class, you can make horizontal comparisons. Because there's so much variation among American states, you can actually compare a number of whatever you're looking at across American state lines. A crude way of doing this, a Federal Reserve Board of San Francisco report in 2002, compared California, which doesn't enforce non-competes, with the rest of the world, which does enforce non-competes, the rest of America anyway. And lo and behold, California had higher rates of growth and tech growth and so forth. Well, that's really crude. I mean, honestly, there are lots of reasons why California is California and New Jersey is New Jersey. We don't really have to go into that. But things have become very, very much more sophisticated the last few years. Olaf Sorensen of Yale and his associates have developed a 6-factor index of high non-compete enforcers and low non-compete enforcers, so you can develop more nuanced senses of high enforcement or low enforcement. Will the courts rewrite the agreement? Do they ever enforce anything over 2 years? That sort of thing. Those are the 6 factors. Okay, so when you do that, you can actually run U.S. comparisons and leave California out, if you're the sort of person who wants to leave California out. And lo and behold, it turns out in an article by Samila and Sorensen. Samila actually teaches at Brock University here in Canada. Samila and Sorensen, which was just out in Management Science this year. It's been circulating, unpublished for a while. If an American state does full enforcement of non-competes by their standard, comes out positive on all 6 high enforcers, it will have reduced startups, it will have reduced venture capital, it will have reduced employment, and it will have reduced patenting. Now, that's the key figure, folks, because the traditional justification for the non-compete when you say, well, why are you permitted to do this, is there's an intellectual property justification, right? We don't want the justification for enforcing the non-compete against the employee is he's taking our information, our secrets. We need to keep that information in-house because we're doing something with it, okay? Well, it turns out the firms may keep the information in-house, but they're not doing anything with it. You get more patenting when the employees can move around than you get patenting when they force them to stay in their original firms. Mark Armaze from UCLA School of Business looked at executive compensation, an interesting database. There's a big database on executive compensation. He compared managers in jurisdictions that enforce non-competes with managers in jurisdictions that don't. And he also has a somewhat multi-factored test, so he can also run results that exclude California. And sure enough, if you manage in a company that enforces non-competes, you will be paid less. Well, obviously, you have less bargaining power. You can't really threaten. I mean, what's the bargaining power that an employee has? I can threaten to leave. If you can't threaten to leave, why would they pay you more? The employees, if they do succeed in moving, they are paid less afterwards. Garmez interprets this as they're investing less in their own human capital. I'm not so sure about that. We could talk about that. But that's how he interprets the fact that so if you start in a jurisdiction that enforces non-compete, say a heavy enforcer like New Jersey, you'll make less while you're there, you'll make less on the next job, and the firms definitely invest less capital per worker in a jurisdiction like that. Matt Marks of MIT and associates, Lee Fleming of Harvard, have looked at patent records. Okay, so we've got all these different databases, and they're all ending up in the same place. Indeed, the punchline of this is I've never looked at economic data that all lines up in the same direction before, right? Usually as a legal scholar, you go, oh, the economists must have this all worked out, and you go look at economics articles, and they're a mess. You know, they come out either way, and there's something for everybody. And never in my life have I gone to look for economics articles on a question, should we enforce non-competes, and found so many articles with so many different databases and so many different ways of massaging the data, but with such uniformity of results. All right. So Marx and his colleagues look at patent records. They develop career histories of inventors, people who filed patents. They have a huge database of inventors who are awarded patents, and they look to see how often they move, because you can tell when people file patent applications, they have to put an address. So it's easy to tell whether they're in the same address they used to be. And lo and behold, over time, there's what they call a brain drain from jurisdictions that enforce non-competes, high enforcers like New Jersey and Pennsylvania, to non-enforcing states. 34% more likely to patent the move, that's not the likelihood of patenting, it's the likelihood of move. The move is much more likely to a non-enforcing state. It's even more likely if you leave California out. Okay, so those are some of the horizontal comparisons of high enforcing U.S. jurisdictions with low enforcing U.S. jurisdictions. There's also an interesting before and after study, also by Matt Marks and Lee Fleming. This was also in management science, I think. The state of Michigan, before 1985, apparently the law was like California. Like California, they had a statutory ban on enforcing non-competes. In 1985, they did a codification, and as a result of the codification, the statute disappeared. No one takes responsibility for this. Everybody insists it was an inadvertent accident. So after 1985, the Michigan courts began enforcing non-compete. Michigan got nothing out of this. Mobility among inventors dropped. There was no increase in venture capital, and there was no corresponding increase in patents, again, like the other study. Michigan employers had greater ability to prevent their employees from moving, but they didn't do anything interesting with this information. Now, I hear you asking, right? Michigan, automobile industry, 1985, the whole place was going down the tubes. How important was this in the overall scheme of things? They ran their results excluding inventors who worked in the automobile industry, and the results were not different. But you're entitled to think that the problems of Michigan extended not just to the automobile industry, but to other industries too. So I'm a little less moved by this one. I'd like to see some more before and after studies, but they're hard to arrange. Okay. And Marx, again, is, so far as I know, the first study to look at what actually happens to people who become subject to non-competes. No one's ever looked at this before. He assembled a database of 1,000 individuals in automatic speech reduction. This is just out in the American Sociological Review. 1,000 individuals against whom non-competes have been successfully enforced, that is not in California, but in states like Massachusetts, and then did in-depth interviews with over 50 of them. He limited himself to patented inventors in automatic speech recognition software, a field where he used to work before going to graduate school. And many subjects of non-competes never work in the industry again. They have career detours. They do something else. So there's a big waste of human capital. All right. Well, what would actually happen then if the whole world became like California and employers couldn't enforce non-competes? There would be, I'm arguing, more information across firm lines, more startups, more venture capital, more patenting, more tech growth. Would firms be left defenseless? Not necessarily. They would still have trade secret law, although by my lights that ought to be trimmed a little bit too. We can talk about that. But whatever your trade secret law is, they would still have that. They would have informal norms. Certainly the most entertaining article in this field is by Fauchard and von Hippel, dealing with intellectual property norms among French chefs. Right? Don't read this one before dinner. Okay? Recipes are not covered by any known scheme of intellectual property. Right? They're not trade secrets. They're not confidential information. The restaurants can't enforce non-competes. There are nevertheless very strict norms among French chefs on any continent about what you can and can't do with somebody else's recipe. And if you break those norms, you are in trouble as a French chef. Everybody will, make your life very difficult. Okay? Very interesting article. No doubt other industries have informal norms like this too. And if we decreased legal enforcement of intellectual property, other informal norms would increase. But we don't know what those are. And then finally, the solution in many countries is if you don't want the employee to leave, you can pay the employee. I'm told this is the solution in France. I'm told this is the new solution in China. I don't know how this works, but there can never be an objection to that. All these firms seeking enforcement of non-competes are trying to get the law to write them a contract where they were just too cheap to prevent the employee from leaving. All right, so this is the state of current research. I'm now coming out swinging in a way I didn't really do in the 2003 book. I think there's better data than I had then, and that, to my mind, almost everybody would be better off if they didn't enforce non-competes at all, like California. Nevertheless, this leaves many questions for future research. I'll tell you the ones I see. Maybe somebody in this room will do a paper or a law review note or something along these lines. First of all, at least as I see it, there ought to be a very heavy presumption against enforcement of non-competes, and the plaintiff ought to show a much stronger case than the American Law Institute or Canadian law, as I understand it, permits the plaintiff to show. You would have to show some very special circumstances why you're different from the run of employers who don't need to enforce non-competes. It is true, however, that the literature, as you've seen throughout, is very heavily shaped by the experience of Silicon Valley, California, information technology. This may be an unusual industry. There really aren't any secrets in IT. Anybody can use a program. Anybody can reverse engineer a chip. The median time to obsolescence of information is months. So there just aren't a lot of secrets. It may well be that there are other industries that could have a more persuasive case for better trade secret protection. Again, I'd rather see it as trade secret protection that was industry-specific rather than a rule on non-competes, which applies to many different employers. There's an amazing absence of discussion of biotech, for example, where one assumes that there's probably a greater need to enforce secrets, same as pharmaceuticals. Second of all, we know almost nothing about how managers cope with this. I did some interviews in my book with managers. They're not a representative sample of anything. They reflected ties I had in the industry. But high-velocity labor practices, heavy turnover of employees, these are now very well established in your country, in my country, and certainly in some industries. And we don't have studies about how managers cope with the fact that your employees could walk out the door at any minute taking secrets with them. Some of the literature hypothesizes that managers in those circumstances will withhold information, not put any employee in the position where the employee can hurt you, divide up tasks among other employees. I did ask about all this when I was doing interviews in Silicon Valley, and people just laughed. I mean, that has just nothing to do with how products are brought to market in tech in California. You can't divide things up that way, But there may be other industries that do, or there may be other kinds of tasks that do. We just don't know very much about that. We know nothing about the micro mechanisms of how employee mobility increases productivity. I don't think the basic conclusion is open to doubt anymore. At least in tech, Mobile employees are positive for productivity. Every study confirms this. But why exactly, right? I've talked about information flows across firm lines. But a lot of employees in tech are highly mobile, and they're not really transmitting information across firm lines. Software testers, kind of low-level programmers. All these programmers hired in my country on short-term visas. Why are they positive for firm productivity? The tech firms in California aren't really interested in the property they carry with them. Is it possible that employees have more incentives under this system? That's been hypothesized, but we have absolutely nothing that looks like data, right? If you're, for a certain kind of employee, knowing that you have to make your own career, you're going to be on the job market soon, you'll be looking for a job, that creates incentives to keep yourself current and educate yourself, whereas the old-timer at the internal labor market's waiting for the gold watch. Maybe. It's a bunch of stereotypes. Maybe, but we don't have a very good sense of the dynamics. Is this part of a deal to induce employees to accept precarious employment? The employees are giving up a lot when you leave an old-line employer like AT&T or Pacific Gas and Electric to move to a startup. Right? This happened all the time. Your friends have started up a firm. Come join us. Gee, I don't know. I got a great setup where I am. Right? Well, come to us. Okay? Well, employees will do that, but only if it doesn't work out, they can be back on the job market and trade on that information. Again, that makes sense to me, but we don't have any kind of comprehensive data on that. Informal norms, as I say, there are definitely informal norms about information sharing. We know what they are with French chefs. We really don't know how they work in other industries. Yuval Feldman did some interesting interviews with engineers in Silicon Valley about their informal norms of information sharing, and that's the whole literature so far as I know. 5, behavioral economics has a great deal to contribute to this problem, but very little use has been made of it. In 1952, Fritz Machlup, one of my favorite economists of all times, wrote a very mordant analysis of intellectual property. And he said the most efficient intellectual property for society is one in which the rights holders think they have really strong intellectual property, but nobody else does. Right? So the firm thinks, we've got all these things locked up in patents and secrets, so we can exploit the patent, and everybody else can zip right into the market and be a fast second and make the knockoffs and the competitions. And I thought that was kind of a mordant observation. And that sort of describes California, as I understand it, where the firms put a lot of investment into thinking they have secrets, but actually they don't really have any secrets at all. Everybody knows what's going on in the valley. The people these days who think about behavioral economics could probably formalize this into a more formal kind of model, but nobody's done that so far as I know. 6, as I mentioned, my talk is very Americocentric. At least the American solution for spreading technical information among firms is to rely on employee mobilities, but other countries may do it different ways. It's been suggested in Japan there's very little mobility of technical personnel, but Japan has its all-powerful Ministry of Trade, and they play a big role in conveying information about best industrial practices from Japanese firm to Japanese firm in a way that we would think really isn't really true to the spirit of competition as we understand it. There may be other social institutions, in other words, that provide ways of getting information across firm lines, and for all we know, in different cultures, they could be as efficient as employee mobility is in California. And then finally, all this needs to be globalized. Paul Samuelson, in one of his last papers, argued that the traditional arguments for gains from trade break down in a contemporary economy where people specialize either in manufacturing or information. In other words, in the example, if you were an undergraduate economic major, you saw this example probably 6 times before you graduated. The traditional defense of comparative advantage in trade is that countries will make things as to which they have comparative advantage. So, England will make cheese, and England will make cloth, and Portugal will make wine, or something of that kind. I forgot what it is. My son once told me all the different examples that had been used in his undergraduate economics classes. And from this, David Ricardo, who invented this way of thinking, concluded that everybody benefits when there's free trade. Samuelson said, it's a jump. It does not follow that if China specializes in manufacturing and the United States and Canada specialize in technological innovation, that the market will work the same way, not in a world where that technological innovation lasts until your next scientist returns home to China and exploits it there. This might be a good system, but it's not Ricardo's system. It doesn't. The models don't work the same way when some kinds of information are much more local and other kinds of information zip around the world with today's mobile scientific workforce. So extending the fact that, and I do think it's a fact, that firms in California have found that their interest lies in mobility of personnel and no longer complain when their engineers move to a rival in Silicon Valley. It does not necessarily follow that over the next few decades they will feel the same way when their engineers take this information with them to China or India or other emerging technological powers. But how that works is certainly beyond my time today, so I will leave it as a question for this group. Thank you very much.
So we have time for questions, comments, challenges. Yes, Josh.
Please introduce yourself to me, too. I hope to meet some folks here.
Hi, Josh Hyde, teach here. I don't know much about labor law, but I teach contracts, and my question sort of comes from that point of view. It seems to me, and I'm convinced by your case, that non-compete clauses are an aggregate hindrance on the economy. But they may still benefit a firm who seeks to enforce them. And yes, they get a benefit from a new information stream from a departing employee, but that might be outweighed by intellectual property that's not being shared. So if you were to make non-competes unenforceable, it seems to me it might still be worth it for a company when they know an employee is departing or thinking about departing to execute a separate contract of just payment of some sort in return for keeping information that they could otherwise communicate secret. So do you think those ought to be unenforceable as well? Because then that starts to get a lot broader. But maybe we know.
Well, it's certainly an improvement. That's a refinement that I'd never thought of. And so far as I know, the case law doesn't reflect. I mean, the truth is, every non-compete case I've ever seen, the non-compete is signed at initial employment, or perhaps it's distributed later. And then sometimes old-fashioned contracts courts then start running, games whether there was consideration for the non-compete and whether at will. That's another dimension on which American jurisdictions differ. Texas says in order to enforce a non-compete, you have to have paid for it somehow, and a promise of at-will employment isn't consideration for a non-compete. They sometimes like it the old-fashioned way in Texas. In other American jurisdictions, a promise of at-will employment is consideration for a non-compete promise. If we said you couldn't enforce it at the time of employment contracting, but it had to be a separate agreement with separate consideration, this would not be unknown to the law. That would certainly be an improvement. I just don't, I don't know enough jurisdictions to do it that way to have any data on it. I would still be bothered by the anti-competitive aspect of it. I mean, in my experience, the overwhelming number of firms that are plaintiffs in non-compete cases and also in trade secret cases, they're not really interested in the information. They're interested in interfering with a rival's appearance on the market. A much cited, although not followed, American trade secret case is the PepsiCo litigation, PepsiCo against Gatorade, on inevitable disclosure of trade secrets. If you don't know what that is, then feel proud. I'll explain it if you want. But it's the most pro-plaintiff recent American trade secret litigation. Permitted PepsiCo to enjoin an employee, managers moving to Gatorade. They couldn't identify what the trade secret was, but they said if he moves to Gatorade, he'll inevitably disclose something. Of course, today PepsiCo owns Gatorade, irony, but at the time they didn't. He'll inevitably disclose something. Well, I did interviews with the lawyers in that case, writing about that case, and they were perfectly frank with me that when PepsiCo went to them, they had no concern about trade secrets at all. They were concerned about Gatorade poaching their employees. A charming metaphor, right? This is a free country. There's no such thing as poaching an employee. The employee is not your property. In fact, they were so unconcerned were they about trade secret. The very employee who was the subject of this case, his boss had moved from PepsiCo to Gatorade 6 months earlier, and that didn't bother them at all. The boss had more trade secrets than the underling had. It was when the second one moved that they thought, these folks at Gatorade, somebody's got to teach them a lesson. And the lawyer told me, I said to them, he didn't sign a non-compete. He didn't. You have a confidential agreement. It's boilerplate. It doesn't do anything. Well, maybe we could do something with trade secrets, says the lawyer. They go, oh, maybe he does have some trade secrets of ours, right? So, maybe I just know the cases I know. Maybe I'm too cynical. But anytime you let the old employer sue the departing employee, you have to recognize that for every case that's sincerely motivated by concern about intellectual property, there are going to be many more that are just attempts to prevent competition in the product market, and that I think would also be true of your system too. Yeah, Bina?
Thank you for that wonderfully engaging talk. I had a couple of different things I was going to throw out there just to get your views on. One is the scope or potential for the law of restitution, given that the Americans are going through the third round, the third restatement on the law of restitution. So how much attention has been given to this outside of trade secret, breach of confidence, and the enforceability of the non-competes within that process? So that's one. And the second point I had in terms of working hypotheses for increased productivity where they're not enforced is whether, and I'm just thinking out loud here, whether that relates to the classification of certain types of knowledge, codified knowledge versus tacit knowledge, and the ability of employees, regardless. In my mind, what RP tries to do is fence off the codified knowledge, whereas tacit knowledge has a lot of its own productivity gains and may explain some of the increased peaks in patentability. So I'm wondering whether that kind of breakdown makes sense also in terms of what we see in Silicon Valley, insofar as the codified stuff may be already sufficiently covered with copyright, for example, and therefore the patents aren't, or the non-competes are not as that imperative for enforcement. So maybe you could just comment on these things.
Well, that's an excellent question. Take the easy one first. So far as I know, the current restatement of restitution is not going into trade secret issues. The first restatement of torts did, and the second restatement of torts left it out. So that's why I picked this definition from the employment law restatement, because this is the most up to date. I'd actually really be curious if anyone knows the way Canadian courts talk about that, if that kind of definition sounded familiar to you or sounded peculiar to you. On the difference between codified and tacit knowledge, yes, excellent question. I'm painting with a broad brush here. Basically, the comparison in my talk today was information that's probably not protected by any other intellectual property regime other than the non-compete. So it's either the non-compete or free-flowing information. And that can be, the subheads under that category would be firm plans, products, and things that don't rise to the level of trade secret protection. They're not actually secrets in the industry. Tacit information, things that employees know about how to do their job. Because if I'd make that exclusion, because if an information is protected by patent or copyright, then you have a whole other enforcement regime. It doesn't matter if it's a departing employee or anybody else. But to really get a comprehensive picture, you have to put those all in. I was in my book, I played around with, but ultimately it was rather. Some authors approach this by making a strong distinction between codified information and tacit information. The American law of trade secrets does not. There are some older cases that used to say it's only a trade secret if it's written down, but those the restaters claim those are obsolete everywhere, and the restatement takes aim at the last few survivors. American courts are quite clear that something can be a trade secret even if it's not written down, couldn't be written down if it's lodged only in the employee's head, algorithms the employee knows, everything an employee knows about how to do the job better. These are all trade secrets in American parlance. I felt writing the book that the distinction between tacit and codified information had been somewhat overstated as applied to my problem, that the problem covered both. But I'm open to persuasion on that.
Just coming in from my own background in biopatents, that's my own particular specialty. I just remember that Watson and Crick in their writings said that one of the reasons they sort of came upon the double helix shape was because of Linus Pauling's helices were in the air, right? So by virtue of being in a similar environment, and we see that, right? We see triangles of knowledge development. And so by virtue of being familiar with people attending conferences and having that sort of tacit information exchange, that sort of moved them towards the discovery of the DNA shape. So I just thought I'd held that back. Thank you.
So I have a question that I think you've partly kind of answered, but maybe you can flesh this out a little bit more. And it's possible to imagine two sorts of responses to your argument. One would be, let's go with it, let's not enforce non-competes anymore. Another might be to say, well, maybe we should tailor the rules around the enforceability a bit better. so that, for example, they become more enforceable where you have lifetime employment, as your students at least were suggesting might be a good idea, and less enforceable in a high-velocity labor market. You might tailor the types of property interests that can be protected this way. And I guess I'm wondering if there are dynamics in the market or incentive problems or coordination problems that would push you away from that tailoring exercise and towards the full non-enforceability. I can imagine what some of them might be, but I'd like to hear your thoughts on that.
Well, all I can say is I spent a lot of time in California looking for the costs of California's regime of total non-enforcement, and I couldn't find any. But, I mean, that doesn't mean there aren't any. I didn't start off being as militant as I was, as you may remember. I was going to organize the book around a contrast between a somewhat old-line tech firm like Hewlett-Packard or Cisco, where people could make careers, or Intel, and a startup in the world of startups. Well, during the years I was writing the book, there stopped being old-line tech firms. That is, Hewlett-Packard and Cisco started having layoffs for the first time in their history. They started outsourcing. They were becoming more like a high-velocity labor market. Every firm where I did interviews, I always said, has there ever been a project that somebody proposed around here and someone said, no, that doesn't make any sense because given the way the employees move around here, we could never bring that product to market. The information would just walk right out the door before we could bring it to market. And nobody could ever think of an example like that. So as I said, I spent a long time looking. When I started that Silicon Valley book, I wasn't necessarily a booster of high-velocity labor markets. I really just thought they were the wave of the future, and I wanted to see how it worked. Now, just because I couldn't find it doesn't mean it's not there. So based on the California experience, I would be very happy if the states where I live became like California, didn't enforce non-competes at all. But if people aren't willing to go that far, certainly the ALI couldn't go that far in restating American law. We do enforce non-competes in America outside of California. So intermediate steps would be to make the reasonableness test a more meaningful test and put really more of a burden. Start with a presumption against non-competes. It doesn't have to be a formal legal presumption. Just the judge has to know something about how it works in California. And then require the plaintiff to meet a standard of really showing why you're different from other people, why you're not just like everybody else. And then we'd learn some stuff. Then people could actually come in with stories about what makes our firm different from other firms. That would certainly be an easier bite first time around. I do have this nagging doubt about pharmaceuticals and biotech, and it's just surprising to me that there's so little academic literature on those companies. I suspect they would have a different story, but I did do some interviews in biotech. People told me that the problem in biotech was not really concerned about mobile employees because usually the time to bring a project to market was so long, it took so long to have results that an employee could rarely bother you by leaving mid-project and going to a rival. But surely that's a generalization. There must be exceptions to that. So there are more nuanced positions possible than my scorched earth approach here.
One follow-up question.
Sure.
It struck me that there is a broad similarity between the test in Canada and the various tests in the United States, at least structurally. And that at each level you have fairly vaguely defined general criteria that are probably subject to a good deal of scope for argument and uncertainty. And I wonder if there might in that lie a bit of a stronger case for moving towards a complete non-enforceability regime. That there's potential for abuse in a highly discretionary application of a multi-factor test.
Oh, absolutely. A regime where it really is a multi-factor test, it almost invites firms to try to prevent competition from arising, to interfere with a rival. These cases are heard in equity. You're typically it's rare to be able to recover an interesting sum of. You can never recover anything interesting from a departing employee, and calculating the damages of how much you lost when your sales director or research director went to a rival, it's almost incalculable. So the only remedies that matter for firms are remedies at the injunction stage. You want to get a preliminary injunction against your engineer or sales manager, whatever, taking that position with a rival. So it's all done very quickly. The preliminary injunction is what it's all about. There's not a lot of witnesses really, or affidavits and things. And clearly, as I say, a lot of this litigation is brought to interfere with a rival. And then later on, you have the permanent injunction proceeding, but it's still typically in equity. Should I tell the joke? I have a law school classmate who's my reality check on so many issues, and he's done commercial litigation in New York since we graduated from law school, many years ago. And some years ago, he remarked that the category of litigation that he finds the least predictable in the New York courts was litigation over noncompetes. That he'd litigated a lot of them, sometimes for the plaintiff, sometimes for the defendant. He'd won some, he'd lost some. When it was all over, he never really had a sense of what had moved the court one way or the other. So, I used to quote this to my contracts class every year when these issues came up in contracts. So a couple of years ago, I ran into him. I said, I'm about to quote you in my contracts class. He said, no, I've solved the problem. I figured out the law of noncompetes in New York. I said, that's great. So here's the Richard Zuckerman rule of noncompetes in New York, and you can write it down and use it if it helps you. He says, if the departing employee against whom enforcement of the noncompete is sought makes less money than the judge will not enforce the noncompete. Because how can you interfere with this poor man or woman's right to make a living? But if the departing employee makes more money than the judge, and especially, as sometimes happens in the American economy these days, if the departing employee is younger than the judge and makes more money than the judge will enforce the non-compete. What is this? How could this ungrateful whippersnapper turn on the people who trained him or her? So. Now, this is a potential law and society study. Zuckerman didn't have the data on this, and neither do I. We could assemble a database of non-compete cases and regress some variables about age and see if there's anything to this theory. I haven't done the work. I just pass it on to someone who's looking for a paper for the next Law and Society Association. Yeah.
In recent Lawyers Weekly here in Ontario, there was a discussion of a class action case where the expert witness was actually a law professor in law and economics. And I wonder, in these non-compete court cases, is it common for the defendant who doesn't want it to be enforced to be calling economists or law professors?
Well, I know of one. It was one of the best things that ever happened to me as an academic. But when first time I was out in Silicon Valley doing interviews in '96, I learned that Kenneth Arrow had appeared as an expert witness for the defense in a trade secret case. Now, California doesn't enforce non-competes, but there was some interest in the 90s in employers attempting to use trade secret law to do the same thing, and that was largely unsuccessful. That's a story I tell in my book. So in one of those cases, Kenneth Arrow had appeared as counsel for the defense. So I phoned him and said, did you write out your testimony? Because and he said, no, I didn't write it out. Just come to my office and talk to me. And he spent an hour with me with students. I was just an unknown law professor from the East Coast, and with students waiting outside the door. And it was one of the things that really gave me a feeling that I had a really good research topic and I had a really good handle on it. And he gave me a number of leads to. I think it was from him that I learned about Eric von Hippel's work. So I know that it happens, but at least in tech in California. But what's the word I want? I want to say these cases are not well litigated. That's not true. They're superbly litigated. But they're litigated under enormous pressure. They're litigated as equity cases where everything turns around the preliminary injunction. So the employee leaves, says he's leaving, moves to the company. The firm phones their law firm. And often 72 hours later, they're moving for a TRO against the employees taking the new job in federal court. So the associates who do, and there are a lot of slip-ups. They file these affidavits and then they're prepared very hurriedly. That's what litigation on these is like. It's not like the classroom in a great North American law school where we debate the economic theory. But so in Ontario, this case was about an expert witness, and did he or she do well?
That's what the news story was all about, is that we don't think of calling law and economics professors.
Oh, I see. We should.
witnesses.
Right. Why don't you call me as a witness? here's my card and my hourly fee. Okay, well, all right. I'm available. Okay, I'm available. If anyone wants to call me. No one's ever called me as a witness. I've been asked to be a witness, but to fit within legal categories that I don't care for. I was asked to be a witness for the defense. Yeah, sure. I usually tend to be for the defense of these things. To say that there was really no danger if the employee went to the rival because the employee would be able to compartmentalize his mind and not make use of what he'd learned at the old job. I said, I think that's impossible. I mean, I'm sorry. I think employees should be able to move around, but that's just not psychological. I mean, when we do that, we have to face reality, which is on the new job, they will be asked questions that will draw on what they learned on the old job. Why hire an experienced employee? Why not hire somebody fresh out of school? And the only reason you hire an experienced employee is because you think they learned something on their old job that you could make some use of. So at that point, the lawyer was not interested in my expert testimony. Yes.
I'm wondering, in light of what you said, what the incentives are for employees in these high turnover industries to put non-compete clauses in their employment contracts in the first place, even in the states where they're likely to be enforceable. Because wouldn't it be more attractive to employees who are considering taking employment with a company in this industry to have the employers say to them, well, we realize how the labor market works in this industry, and we're not going to bind you to a non-compete.
Well, that's exactly what happens, at least in some cases, at least in tech, at least in California. These other clauses in California, I was surprised at the figure that they're so widely used when everybody knows they're unenforceable. They must have some kind of in terrorem effect. It's like, but we encounter these things in other areas of law where the retailer will use some consumer debt collection technique that the courts have said was unconscionable or violates consumer protection laws, and they still keep them in the contract so they have something to threaten the consumer with. It may just be that. The most revealing interview I did for my book was at Intel, which at one time had a very aggressive, unusually for Silicon Valley, had a very aggressive reputation for suing departing employees. And there was a widely publicized case in which they had sued several employees who were attempting to create their own chip production firm that was going to make chips that were compatible with Intel's. And Intel went on for years, and Intel lost. They lost the injunction. They lost the criminal proceeding. They lost the civil suit. And a high source within Intel, one of their top lawyers, said to me they were never going to do that again. That case was a recruiting disaster for them. He said chat groups lit up all over the valley, and that year when we went to Stanford Engineering School to recruit engineers, everybody we talked to said, if I go to work for Intel, you're going to sue me if I leave after a few years. So, that's interesting because it's a standard law and economics tropey that we don't need so much law because reputational sanctions will help us all. Firms that are bad actors will get a bad reputation. And usually, we take this with a grain of salt, and if we're labor and employment lawyers, you take it with a big grain of salt. Come on, how are these reputational sanctions supposed to work? People in this economy take whatever job they can get. But lo and behold, right, you could cite my book, at least sometimes in some job markets, reputational sanctions was all it took to get Intel to stop suing employees, at least according to my source there. But it's a mixed bag. I wouldn't be surprised if they still left the non-compete in the contract, even though they knew it wasn't enforceable, and it probably wouldn't be in their interest to enforce it or enforce trade secret theory, just to have something to yell at the employee about. But I regret that I didn't ask that question. I was surprised that finding how many California firms still have non-competes in their contracts, even though they're not enforceable.
I'm going to tell my son that who's the chief financial officer of a little startup in New York City, and the de facto human resources officer could have got to human resources. Take the non-compete clauses out of your employment contract.
Well, they could try. Now, in New York, unlike California, it does enforce them. It's not a high enforcer. New York actually does require a legitimate interest, and it usually has to be a trade secret or intellectual property interest. New York is not as high an enforcer as New Jersey, but I'm not sure that. I'm not sure. My talk is about the policy level. or the law level. I'm not sure it necessarily follows that every employer would realize advantages from taking the non-compete out. But at least your son's firm could consider whether that would help them recruit abler, more energetic, more ambitious employees if they could be assured in advance that when they left this job, as they would, if it's a small startup, they're not offering lifetime employment to anybody, and frankly, in the States, nobody's offering lifetime employment to anybody anymore. So you're not giving up anything if you say you're not doing that. That they might get better employees if they assured them that when they're back on the labor market, there'd be no interference with their mobility, and they try to stay friends with former employees and so forth. Who knows?
Great. Well, thanks.
Okay. Well, thank you all. And, I didn't learn what I'd hoped to about Canada.